Does CCPA compliance apply to call center data? Have you ever wondered how call centers handle your personal information? Today, we will discuss whether the California Consumer Privacy Act applies to call center data. This is an important topic, especially for those who value their privacy. Yes, the California Consumer Privacy Act does apply to call center data when the call center collects, processes, or stores personal information of California residents. The California Consumer Privacy Act is designed to give consumers more control over their personal data. This includes any information that identifies, relates to, describes, or can be linked to an individual. Call centers often handle such data during customer interactions, making them subject to California Consumer Privacy Act requirements. Let's break down some key points relevant to call center operations. First, call center data typically includes audio recordings, call transcripts, customer names, contact details, account information, and other personal identifiers. Under the California Consumer Privacy Act, these are considered personal information and must be handled according to the law's rules. This means call centers must disclose what data they collect, how it is used, and with whom it is shared. Next, call centers must obtain clear and informed consent from customers before recording calls. The California Consumer Privacy Act requires proof of such consent. Agents should be trained to request permission properly and document it during calls. Customers also have the right to be informed about the purpose of data collection at the point of interaction. Customers can request access to all personal data collected about them. They can ask for deletion of their data, opt out of the sale of their data, and request data portability. Call centers must have processes to respond to these requests within specified timeframes, typically between 45 to 90 days. Call centers need to maintain a detailed inventory of data collected. This includes sources, storage locations, usage purposes, and access controls. This helps ensure compliance with data retention policies and facilitates responding to consumer requests. Call centers must update their privacy policies to include specific disclosures mandated by the California Consumer Privacy Act. This includes categories of personal information collected, sources of data, business or commercial purposes for data use, and third-party sharing practices. Staff training is essential so agents understand California Consumer Privacy Act requirements and can handle customer data appropriately. Call scripts may need revision to include consent language and information about consumer rights. For practical applications, call centers can implement call recording systems that capture consent and store transcripts securely. They should develop clear procedures for handling consumer data requests and ensure timely responses. Regularly reviewing and updating privacy policies and data management practices is also important. Training agents on privacy compliance is key. Focus on how to communicate with customers about data collection and their rights. Conducting periodic audits of data access and third-party vendor agreements ensures ongoing compliance. In summary, the California Consumer Privacy Act is directly relevant to call center data. Call centers collect and process personal information during customer interactions. Ensuring compliance protects the organization from legal risks and builds customer trust by respecting privacy rights.